last week in the oral statement of my right honourable friend, the Home Secretary, it is crucial that we act now to ensure that our law enforcement and intelligence agencies have the tools they need to keep us safe. I will give way.
Him for giving way. He says this is incredibly urgent. If it is so urgent, could you explain why this wasn't brought forward 3 months ago, as soon as the Court of Justice hearing was announced? Why are we doing it one day just before recess?
Well, I think my honourable friend, the Home Secretary, explained this clearly in her statement last week. There was the judgment that was made last April. It has been seeking to get clarity on the form of that judgment, and indeed the pressure that has come to bear from other legal challenges and also from the industry itself to give us clarity on these really essential measures and tools around the ability for law enforcement and for our security services to be able to assure us of our national security and also to combat crime. But I'm quite sure that we will get into those issues in the substantive debate, and I don't want to detain the House too much on those substantive issues.
We can rest assured there will be no proper answer ever given as to why this has got to have a first reading, second reading, third reading, each one voted on and put through as a bill put through in hours, in fact, in hours. Almost unknown in government, under the name of security, national security. Now, Europe decided that they were making it illegal for people to hold information for such a long time back in April, months before, and now suddenly they're now deciding months later it's got to be done within 24 hours. It's got to be done within 24 hours. There's MPs on here, you will see, I'm going to record, MPs on here that have come out and said never in the history of their service in politics have they ever seen anything so ridiculous that can't be discussed, has to be voted in, has to go through, and they won't say. They still have not said why they want it to go through. Now, let's look at this. This happened in the States. People have hardly any rights whatsoever in the States now. They can kick your front door down, they can take what they want, they can say what they want, they can record your phone calls, they can take information from your computer, either remotely or physically, and there's nothing that you will be able to do about it. I'm going to try and put as many alternative viewpoints from opposing MPs as to what the government is trying to do. There's some excellent points made by other MPs where can they make assurances that our civil rights are not going to be taken away, and the answer is no. They can't. We'll bring these on now. Just look at this one.
Agencies. I give way to the honourable gentleman.
I'm very grateful. Can I ask the honourable gentleman why there was no discussion with other parties outside of the Liberal Democrats, Labour and the Conservatives, even on Privy Council terms? If there is an urgency, for heaven's sake, why keep most of this side of the House in the dark? It's absolutely disgusting and disgraceful and undemocratic.
Well, we have had engagement around the purpose, the nature of this bill, and there have been discussions across the House, but clearly there will be
the discussions were on their terms. I've seen some of the answers, and they haven't come out and specifically said what the issue is. Why is the urgency right now? Today. Got to be done. Sorted today. Here's yet another MP who's questioning why the techniques are being used and why the urgency.
Order. There is no time limit on speeches, but before I call the next speaker, can I urge colleagues both to bear in mind the interest of other colleagues in speaking in this debate on the business of House motion, and to reflect on the merits of getting on without undue delay to the central issues involved, which can of course be very fully aired up until 5 o'clock. upon second reading. Sir Malcolm Rifkind.
Mr. Speaker, I shall abide by your request and just make two brief comments on the points that have already been raised. I think the first point is that I think the House needs to take into account there can be two kinds of circumstances when the House is presented with emergency legislation. The first is when a government is seeking new powers to extend its powers in some area, and there the House would have every reason to be very suspicious, very sceptical, and very concerned that this was being done through the medium of emergency legislation. There would have to be really exceptional circumstances to justify new powers of a kind that had not been previously used before. What we are told today, and this is a judgment that also must be made by the House, is that this is a different kind of emergency legislation, which has happened in the past, and that is where, because of some legal judgment, something that was thought to be lawful has ceased to be, or potentially ceased to be lawful, and therefore it's necessary to have this legislation in order to continue with the status quo. That is, of course, a very different matter. The second point I want to make, very briefly, is, of course, there is concern, why was the legislation not prepared 2 or 3 months ago? I think it is quite obvious that there were two reasons. First of all, that there are regulations which were made under the European directive. There is now uncertainty as to whether these regulations might be successfully challenged, and therefore you need clarification right away. And secondly, of course, particularly because it's emergency legislation, it's desirable, if possible, to have all parties' support. And that takes time in the real world, particularly as the opposition, quite reasonably, have asked for some additional announcements to be made in this area that are not specific to the legislation, but very much relevant to it. So I think these are factors that do point to the reason why this is not as unreasonable as it might otherwise sound.
Mr. David Winnick.
Mr. Speaker, I consider this to be an outright abuse of parliamentary procedure. I will certainly vote against the motion, and I hope a number of honourable members would do so as well. Even if one is in favour of what the Home Secretary intends to do so in the manner in which it is intended, to pass all stages in one day, surely makes a farce of our responsibilities as members of Parliament. When one considers the issues involved, how can one justify saying in effect that every stage of this bill must go through by 10 o'clock? Is that our duty and responsibility to our constituents? And bearing in mind, of course, as has been said, the European Court of Justice made the decision in April, July now. And of course, the theatre of last Thursday, the Cabinet meeting at 8 o'clock, the television conference, and then we had the statement by the Home Secretary, all well staged. Can I also make the point very briefly, Mr. Speaker, there's been no pre-legislation scrutiny by the select committees, not at all. This is a sort of issue that the Home Affairs Committee should look at detail, and also other committees relevant to human rights, and none of that has been done whatsoever. I consider that what we should do today is try and persuade the government to give more parliamentary time, be it extending this session as the case may be, or finding other business to be postponed in order that we can go through the stages. But one thing is absolutely certain. I believe every member of this House should now consider very carefully whether or not they're in favour of the measure. Is it right? Is it justified to go through all the stages in one single day? Isn't that a mockery of parliamentary democracy?
This is MP David Davis.
The European Data Protection Supervisor said this. He said that the Data Retention Directive was without doubt the most privacy-invasive instrument ever adopted by the EU. Data retention has been struck down in Germany and Romania and difficulties in other countries, and the two provisions to the European Court came not from bogus organisations, it came from the Irish Supreme Court, the Irish High Court, I beg your pardon, and the Constitutional Court of Austria. So these were very, very serious provisions, and it was entirely probable that the situation we're in today was one we'd find ourselves in. So why have we taken 3 months? Why was this not pre-prepared? Why was not even the deal with the Labour Party struck in advance? Why were we not pre-prepared? My understanding is there was an argument inside government between the two halves of the coalition. And that argument has gone on for 3 months. So what the coalition cannot decide in 3 months, This House has to decide in one day. This seems to me entirely improper. I'll be very fast and finish right here, because the role of Parliament, we have three roles. One is to scrutinise legislation, one is to prevent unintended consequences, and one is to defend the freedom and liberty of our constituents. This undermines all three, and we should oppose this motion.
So there you have it, folks. Undermining the freedom of our constituents. There doesn't appear to be any legislation added to this which protects citizens from abuse of this new law. It's currently a bill, but when it's gone through in 24 hours and 3 hearings, it's going to be law, and your rights are going to be taken away. And doesn't this remind us of the USA, how Obama is now doing executive orders and wants to do away with Congress completely? Is this what's around the corner for us? MP Tom Watson saying it appears an abuse of Parliament.
Mr. Speaker, in the brief time we have, I think I should put on record that MPs have only had 47 minutes to submit unstarred amendments to this bill yesterday. Most reasonable people will conclude that Parliament has been insulted with the cavalier way a secret deal has ensured that elected representatives have been curtailed in their ability to consider, scrutinise, debate and amend this bill. It's democratic banditry resonant of a rogue state, and the people who put this shady deal together should be ashamed.
Sir Edward Lee. I would have thought our fundamental duty is to protect the freedom of the individual. As it happens, I support this bill, but I think that when the Minister sums up, he does, if I may politely say to him, owes a bit more of an explanation. I think it's perfectly fair enough that the Liberal Party, with their tradition, should have objected to many parts of this. There should have been long arguments, objections. Why can't we just be told that? And if that's the case, if it takes 3 months within the coalition to agree to something, then the government could honestly come back to us and say, I'll finish my point. You know, it's taken all this time. We finally come to agreement. Here it is. What is the urgency? It just seems extraordinary that when the matter as fundamental as the freedom of the individual is concerned, we should be rushing things so much.
So, there's one of their own MPs. He said he'll support it. Yeah, that's right, he's got to toe the line. But he doesn't agree with it. He doesn't agree the way it's being done. What he's saying is that people's liberties are being trampled on, basically. They're taking away our rights. Mr. Robin Clwyd, MP.
Very much, Mr. Speaker. I'm very concerned about this rush to legislate because we all know that if you legislate in haste, you may well repent at leisure. Now, we're told that there is a reason, that there is some urgency. Well, accepting that on face value, I still do not think that limiting our debating time in such a savage way is at all appropriate. Now, the Minister, in introducing the bill, and he was supported by the Right Honourable and learned gentleman for Kensington, said that the bill, in effect, is a continuation of the status quo. Well, it isn't. Even on a cursory glance, I found 2 reasons why that's inaccurate. Firstly, at present, public authorities and public bodies are able to gain access to data for a broad range of reasons, as we know. Section 37 of the Protection of Freedoms Act 2012 included a requirement that judicial authorization would be necessary before local authorities could access communications data.
So if you look what he said there, Section 36 or 37, he said that judicial authorization would be necessary. Now, the new bill doesn't require that. So it's not reinstating the status quo. They are lying. The government's lied. They're taking away your rights, so the judicial system may not even be necessary, just like in the United States.
It's absent from this bill. That's point number 1. Point number 2, Clause 5 extends the definition of what is meant by telecommunications service and the explanatory notes to the bill state that the new definition covers companies that provide internet-based services such as webmail. And this means that internet service providers, even those based overseas and hence outside the UK jurisdiction, will be compelled to grant access to data. And that's unprecedented. There will be others, I've no doubt, when we all have something like an adequate opportunity to look at the draft legislation. But in all honesty, I am appalled at the way in which Parliament is being ridden roughshod in this way. And I repeat my point earlier on. On Privy Council terms, the Minister could have come to us as well, the minority party, so we should have been included in any further discussion. It's all very well waving a hand and saying it's extremely urgent, security demands it. I don't accept that for 1 minute, and I think I'm in this place to scrutinise legislation, not to listen to it and be rolled over by it.
Order.
And yet another MP, a lady who is disgusted with Parliament and believes the rights are being taken away both of MPs and constituents.
Diane Abbott.
Thank you very much, Mr. Speaker. I just want to speak to this timetable motion rather than to the content of the bill. And I simply wanted to say that this particular timetable motion is an insult to the intelligence of the House. The whole House will know the guillotine motions are always undesirable, although increasingly common in recent decades. And to ram through legislation of this significance in a day must be wrong. And the idea, when we've had a past session with actually a very light legislative programme, for ministers to come here and say, we've only got a day to debate it in, when there are weeks past, when you could give it ample time. I repeat, it's an insult to the intelligence of MPs. And the other thing, which I'm afraid is not very pleasant about the way ministers are handling this, is bringing it forward a week before the session ends, because they know perfectly well the Lord will be disinclined to keep sending it back if it means extending the session when they would have made their own arrangements. I believe, and I hate to say this because all very nice people, but I believe my front bench has been rolled. All ministers had to do was to raise in front of them the spectre of being an irresponsible opposition and that children will die if they don't vote for this bill on this timetable, and they've succumbed. And as for the Lib Dems, I mean, I don't want to sound naive, but their brand has always been that they are the defenders of the nation's liberties, and they are colluding with this guillotine motion. Whatever you think of the content of the bill, this particular timetable motion has no justification after an exceptionally light session and must bring the legislation itself into disrepute with the wider public, and I will be voting against this timetable motion this afternoon.
That was well said. If you realise what she said is, it's not just what is being discussed, how it's being pushed through. Basically the MPs are all but being gagged. They're being gagged and heads will roll because the constituents will be disgusted at what their MPs have done to their human rights. In fact, your rights, so your privacy is now totally invaded. I'm not sure who the name of this MP is. I think he mentioned his name was Peter, but he didn't quite clearly say. But he makes a good point here about the worst crimes ever committed in history were crimes of the powers over the people, the governments over the people, committed the worst crimes ever over their citizens. And that's what this bill is leaning towards.
A climatic example of the conflict between the rights of the individual and the power of the state as enabled by technology. It can only be understood in the context of the very worst crimes which our country and our society faces. But it is not hysterical for those people who oppose these kinds of measures flatly to do so. The reason is that the very worst crimes in all human history were perpetrated by states against their citizens. It is a fact that we must be extremely careful how we allow technology to infringe upon our rights. If anybody wishes to see just how important, I would recommend they have a look at the transcript of the trial of Albert Speer at Nuremberg, which I put online with Big Brother Watch some time ago. In any event, if somebody supports this bill as an emergency, The key problem is the timetabling will undermine the public's confidence. There are many people across this country who think the state is advancing too far and too fast in putting everybody under surveillance. Banging through this measure so quickly will undermine their confidence further. The government is going to have more work to do to win them back, and I very much wish that it had given us far more time to discuss this measure.
Again, another MP who is saying that people's rights in this country are about to be taken away from them.
Councillors to be short, and I will be short, of course, but I do think it's important to challenge the timetable of this motion, and particularly because here, above all others really, in a sense, the process and the content are absolutely connected. You know, I think there's just no justification at all to be rushing through legislation without proper scrutiny and due process. The Right Honourable Member for Blackburn said that he thought there was no reason not to rush through it. My answer would be the reason is precisely parliamentary sovereignty and the importance of parliamentary scrutiny. That is what we are here to do. The Court of Justice made its judgment about data retention in the Digital Rights Ireland case 3 months ago. Since then, no action has been taken to address the implications of that judgment until suddenly a few days before parliamentary recess, apart, it would seem, from some secret talks that have been basically cooked up between the three big parties to bypass due process when it comes to the fundamental rights of UK citizens. Now, a number of organisations wrote to the Home Secretary at the time of the Court of Justice judgment to express the view that the regulations no longer stood. But at that time, this elicited the response that they were still legally in force and that service providers had been advised that they should continue to observe the notice obligations set out in the data retention regulations. In other words, the Home Secretary knew this point was coming, yet appears to have turned a blind eye. But she's now seeking to fast-track such controversial legislation, I think is deeply concerning. I'm also worried that this bill is an attempt to circumvent other legal proceedings, namely a judicial review happening in this very week that challenges the legality of the Data Retention EC Directive 2009 and could see the regulation declared unlawful by a UK court as well as by the Court of Justice. Any new regulations could also be subject to judicial review if they don't comply with the Digital Rights Ireland judgment. As other honourable colleagues have said, it is outrageous that we're being granted 1 day in which to debate and scrutinise a bill of such significance. Even more outrageous that this is being blamed on a totally manufactured emergency and represented as doing nothing other than maintaining the status quo. That is not accurate. This is a huge power grab under false pretences. Notwithstanding the fact that the status quo has been ruled a breach of fundamental rights, the provisions in this bill, specifically Clause 4, extends the territorial reach of the laws relating to data retention. It brings overseas communication companies providing services within the UK into the scope of RIPA. The implications of this are well understood by my constituents in Brighton, who've been lobbying me since last week. As one says, we have a democratic process for a reason. That reason is to prevent bills like this becoming law on the basis of a nod and a wink. Finally, let's also not forget the Court of Justice judgment that the blanket retention of data is unlawful. Rushing through a bill in 1 day is bad enough. To do so whilst inaccurately claiming that the proposals do nothing more than maintain the status quo is worse, but to do so when the contents of the bill that do relate to the status quo have been unequivocally judged in breach of the EU's Charter of Fundamental Rights is nothing short of outrageous.
So do you realise what she's just said? They've invented a reason to take away people's rights. Even Europe wouldn't grant that. The European Parliament, it's even worse than the European Parliament originally instigated. So it's a false flag to take away your rights as a citizen. MP Jeremy Corbyn, it's basically, his statement is that the lifeblood of what this country stands for is at stake here. It's human rights being taken away from us, totally unjustified.
I acknowledge your entreaties that we be very brief, and normally we wouldn't be discussing timetable motions at any length at all, but I think this goes to the very lifeblood of what Parliament is about. This bill has been introduced in a big hurry. There's been no public consultation on it, there's been no parliamentary scrutiny on it, there's been very little public debate about it, and it is a major piece of legislation that has global implications for what this country does. It is surveillance of everybody's telephones, internet, and everything else. It's a massive piece of intrusion into people's lives, and I think the government is doing a very great disservice to Parliament in insisting that we debate the whole of the second reading by 5 p.m, amendments by 9 p.m, third reading by 10 p.m, then to the Lords, then back here again on Thursday, all done, and then a sunset clause that goes on for 2 years. This really is not an appropriate way that Parliament should be treated, and I think every MP should think very carefully. Why are we here? We've been elected here to hold the executive to account, to scrutinise legislation. This timetable motion is a travesty of what scrutiny of legislation should be about, and I, for one, will be opposing this timetable motion so that we have a proper opportunity to scrutinise and debate this piece of legislation.
Well done, sir, and all MPs should say the same.
Wishart.
Thank you, Mr. Speaker. What we've been asked to do today is nothing short of outrageous. To railroad this particular bill through Parliament, given the sheer importance of what we've been asked to consider, let's not forget, we are bringing forward emergency legislation because the European Court of Justice ruled that what the UK government was doing was unlawful. Now that alone should at least take 2 days of debate. And the Home Secretary says that this is just business as usual. It's not business as usual. There is significant and substantial new powers being added to this bill, whether that's in the case of international ISPs being brought into the frame, or whether that's in the case, as my honourable friend said, that this is having included other webmail services like Gmail. This should all be properly considered by this House. And what do the public make of this? If we're not getting an opportunity to debate this properly, the public are not getting an opportunity to have a look at this. They expect us to be here to debate these things properly. Now, I don't know about any other honourable and right honourable members in this House. I have been besieged by members of the public this morning asking me to come to this debate in order to make the points that they feel are very contentious and they think should be raised. What have we got? Something like 3 hours to debate a second reading. Something like 4 hours to debate the necessary amendments and 1 hour for third reading. It is an absolute utter disgrace that we've been asked to do this in a day. And what about the stitch-up we've got between all the main parties here? It's not just a matter that the minority parties haven't even been consulted or asked about this. Our devolved administrations haven't even been given the courtesy of one conversation about this. In the Scottish Parliament, we are responsible for policing, we are responsible for justice, we're even responsible for administering parts of RIPA. Not one conversation with Scottish ministers about this bill at all. So they have had no opportunity to look at this, to consider this bill as an absolute utter disgrace. I hope that once and for all we reject this and we never ever do this ever again in something so important and so significant and so substantial for the people who elect us to this particular House. Yeah.
Well said, sir. So I think you're getting the picture by now. MPs are disgusted at the way that our human rights are being taken away. His constituents who found out about this have been plaguing him to make sure he turns up and defends the principles and rights of citizens of the United Kingdom, and they are about to take it all away from us. Even the European Court of Human Rights said that this country was acting illegal previously. So what do? They bring in more legislation. They pass more bills to make it law. That's even worse than what we had before. Next MP shows how blanket retention of private information is what the European Court stated that was illegal. It's true, that was illegal.
Very grateful to have given way on that point, but she says that she has brought this legislation in line with the EU ruling, but the ruling made very clear that blanket retention of data was not permissible, that it needed to be specific to a threat regarding a group of people or a particular time. It's precisely the blanket retention of data which has been ruled illegal.
So our government thinks we are fit to have everything recorded and used potentially against us as a future date. In other words, 99.99% of the population are viewed as guilty terrorists unless we're proven innocent. Now we've got the inevitable vote. You know what the answer is going to be.
Order! Order!
To the right, 498. The noes to the left, 31.
The ayes to the right, 498. The noes to the left, the noes to the left, 31. The ayes have it. The ayes have it. Unlock.
Well, folks, there's another step to a decreasing of your freedom. I'm sorry to be so boring and going on, but these are momentous days where a future generation, in fact, in the months ahead, people are going to be regretting of what's just taken place.
There will be, however,
one point here that's a bit ambiguous. The lady's about to ask, this MP is going to ask about okay, political activists. Well, that could be anything. That could be people marching against chemtrails or geoengineering or genetically modified foods, if it's a political issue where one government wants it and one doesn't. There's no reassurance that it won't be used against such people.
however, that the security services in the past have very much taken an interest in political campaigns and indeed in industrial matters, and he will have heard my previous intervention in relation to the miners' strike. Would he give assurances that the legislation that's being proposed will not be used against political activists, or indeed will not be used against trade union activists in situations such as the Grangemouth dispute last year, or indeed the miners' strike I referred to previously?
Obviously, it's always difficult for ministers either to comment on security and interception matters. We don't comment, and that's not just from me. That's consistent governments have not done so.
So it's always difficult for governments to comment on that. In other words, if somebody's got an opinion that the government doesn't agree with, these powers can be used to source information on them and take action.
But what I will be able to help the Honourable Lady in, I suppose, underlining the fact that actually what we're doing tonight is strengthening the position here by underlining that the purpose has to be connected with national security, and therefore it isn't simply looking at the economic well-being. And I think it's an important development that we are putting this on the face of legislation. Indeed, my honourable friend, the member for Cambridge, I think drew reference to that in this way. And I am sympathetic to the amendments in principle, as it seeks to provide clarity around the meaning of economic well-being in law. In many ways, I think to seek to address some of the points that the Honourable Lady has drawn attention to.
I don't see an answer there. It's very worrying. In other words, if it's national security, if you want to expose something the government's been up to that they don't want exposed, then they'll invoke these powers to sort you out. So here we're going to see who's the enemy within.
The lady again.
Concern that many have is that national security in the past has been considered a catch-all, and indeed the miners themselves were considered the enemy within, and indeed much of the rhetoric that we hear in this House from those benches considers trade union activity, and indeed people asserting their abilities through their democratic means of trying to assure their own rights as being a threat to the state, and that's what I'm trying to seek assurances from the honourable gentleman from. He's asking us to pass emergency legislation today, but seems to be unable to provide any assurances as to how they will be used in industrial situations.
I I'm surprised, I'm genuinely surprised the Honourable Lady is making the point in the way that she is, because actually this is about strengthening the governance, about strengthening the oversight, and obviously sitting alongside this in relation to the retention of communications data will be a statutory code of practice in addition, that there will be the rights of the Information Commissioner indeed to look at further audit and oversight around the retention of that. We have the Interception of Communications Commissioner that looks at the use of these powers as well, to try and give that independent assurance to not just the Honourable Lady but others who reasonably and legitimately may want to know that these powers are not being abused, that they're not being used in an expansive way, and how I think our governance and oversight around communications data and also interception has been strengthened over the years. I think a point that was...
So, and nobody's out there to question the governance and the operations. They've already said that this information is being taken and used, and even MPs can't get information on whose information is being investigated, held and taken action on. I think that's Jack Straw now. What the next MP is asking about what the public think about this. They haven't been allowed to be asked what they want the government to do about it and how they feel about it.
Well, I'm grateful to him, but I mean, apart from the fact that he can't count his months, I would like to make the serious point that it would make a difference in the sense that over the summer we could actually be having the public debate. The public cares about this bill. They could actually be speaking to their MPs about it. They've been left out of this process, and then at the same time, if we started in October, we could still then have 3 months in this place, 2.5 months in this place, to have a proper debate.
Correct. There's no reason to force this through in a few hours when the public could be notified about it. It's obviously not only are the public being gagged on this, the MPs are being gagged on this and told what to do. If you want to know how we should feel about this bill, I'll let this MP finalise it up. I'm not sure if he's from West Bromwich, but you'll see him speak now. This MP has been in politics for some time, and he can't believe what's being rolled out upon citizens of this country in such a short time. So I'll let him take the final comment.
Good. Thank you, Mr. Hood. I rise in support of the Honourable Gentleman from West Bromwich East's amendment here. I mean, this really is quite a ridiculous way to transact legislation in this place. I mean, I've had to sit here and listen to a lot of nonsense put forward by some quite respectable people. The idea that we should put something as important as this through and worthwhile as this through in a day really just takes the biscuit, to be honest, Mr. Hood. Look, I am sure there is a huge amount of worthy content in the bill before us today, and I'm sure it is extraordinarily important that business is transacted as quickly as possible. But actually we have a duty of scrutiny and reflection in this chamber. We represent 65 million people. This is not simply a rubber stamping process. And the idea that somehow doing it in a day is no worse than perhaps revisiting it in December, I mean, just doesn't hold water. This is not an argument that will have any resonance out there with our electorate. And I do just say this, there is just a slight undertone in this debate that somehow if you are in this chamber expressing concerns about the way business is being done today, you are somehow complicit in putting the nation's safety at risk. And that really is the last hiding place of scoundrels. And I don't mean that anyone in this place starts from that basis, but we have a moral duty here to scrutinise legislation. And I totally and honestly agree with the honourable gentleman opposite that we need to revisit this sooner rather than later.
Well, John McDonald.
That is what the opinion should be of every MP, and not just every MP, every citizen of the United Kingdom. Over 60 million people are being affected by this, and you are one of them. So you've got to make people aware of this. You've got to make your wishes known, and one day you can make it known to your MP and make it known through your votes.